are now going to return to the United States, and our next speaker is one of the CSLR's own, Terri Montague. We're so happy that you are able to join us today. She is a McDonald Distinguished Senior Fellow and Senior Lecturer in Law at Emory University School of Law and a Distinguished Fellow with the Center for the Study of Law and Religion at Emory University. She holds a Doctor of Law and a Master in Theological Studies, Sustainability, Environmental Ethics from Emory University, a Master in City Planning, Housing and Economic Development, and a Master of Science in Real Estate Development, Real Estate Finance and Development, both from the Massachusetts Institute of Technology. Thanks, Terri.
Thank you, Yolanda, and for the conference conveners for the opportunity to participate today. I think this is such a timely conversation. In the course of my preparations, I noticed that the World Housing Forum convening in Cairo, Egypt in November is taking on the theme, "It All Starts at Home." And so we are indeed in good company and hopefully stimulating and participating in an even larger debate about the significance of housing and ways to combat homelessness. Adequate housing is a human right enshrined in international law. The importance of adequate and affordable housing for health and well-being, for poverty alleviation, and for sustainable cities and communities is well recognized in public discourse, national policy regimes, and international treaties and conventions. The UN stipulates 7 criteria for adequate housing: legal security of tenure, availability of services and infrastructure, affordability, habitability, accessibility, location, and cultural adequacy. And it approaches housing as integrative and more than a simple matter of shelter. As Christy Green has already rehearsed for us in detail, despite international recognition of a human right to housing, the U.S. has yet to ratify these conventions or formalize the legal right to housing. Meanwhile, new actors, approaches, and corporate capital sources gaining dominance in housing markets are making unprecedented demands on communities and housing consumers that expose vulnerabilities in current housing systems in and beyond the U.S. These developments, I argue, intensify the need to translate the human right to housing into an enforceable legal right to housing. My essay essentially frames and engages the right to housing debate as it has been framed in the US. And what I have discovered is that many of the arguments over the last several decades have become outmoded and no longer match the realities in the housing sector. And so I discuss key advantages and disadvantages of situating housing entitlement within a human rights framework. Essentially, calls for a legal right to housing result from stark housing realities and inequities. Today, more than 1.6 billion people worldwide are inadequately housed, and up to 150 million people are homeless. 1 in 4 people globally live in conditions harmful to their health, safety, and prosperity. And by 2030, an estimated 3 billion people, roughly 40% of the world's population, are projected to need access to adequate housing. In the US alone, only 1 in 4 eligible households receives needed federal housing assistance. And there are 650,000 unsheltered homeless persons with projected housing shortfalls of up to 7 million housing units. This especially burdens low-wealth households and marginalized communities. These complementary issues and conditions have caused housing advocates to begin appropriating the right to housing as a human legal right to stimulate greater commitment to social and economic justice. And we know that the core tenets of human rights to housing are that individuals, by virtue of their humanity, not their social or economic status, are entitled to certain minimum forms of shelter, security of tenure, dignity, connection to communities, and opportunities that allow for their human flourishing. The UDHR takes a progressive approach that leaves wide discretion regarding the elements and pace for nation states to implement the mandate for a human right to housing. Nevertheless, there is an emerging taxonomy of approaches and vital lessons to harvest from the human right to housing expressed in the 189 national constitutions for United Nations member states, which foreground the challenges and prove the potential for positive impact. Even those experiencing mixed results on the ground provide important learning for newer democracies and the US. In the US, dueling visions and narratives converge in the right to housing debate. Proponents of the legal right to housing tend to argue from a normative and philosophical posture that emphasizes the wisdom and justice of a home guarantee, coupled with practical cost-benefit reasons that seek to relieve those living unsheltered and without adequate housing conditions. They stress the direct and indirect costs of not fulfilling a right to housing in the US and how it undermines citizenship in a democratic society where political rights are heavily dependent on property ownership and economic rights. Opponents to the legal right to housing criticize the fact that housing markets are too complicated to implement the right to housing, and implementation would be too costly and the benefits too uncertain to make doing so feasible. They dismiss the importance of such a right because of the growing pantheon of housing rights that already exist at the state and local levels of government. Still others equate the right to housing with a mandate to provide a home free of charge to all who ask, and they worry that this will create disincentives to work. The opponents also emphasize the supposed political infeasibility due to inability to gain consensus in a polarized Congress and society. Additionally, they contend that international housing rights exist more in law than in fact, and such legal recognition has been rarely translated into effective domestic legislative and policy implementation. Ultimately, I argue that the quest for housing remains elusive because there's a lack of consensus on the goals and definition of such a right, because the discussions of legal right to housing revives a long-standing controversy over whether the US Constitution indeed authorizes entitlements for social and economic rights, including shelter rights. And the US Supreme Court jurisprudence, or rather interpretations of it, tends to complicate housing advocacy efforts. Thus far, the US Supreme Court has declined to find an explicit constitutional basis for a legal right to adequate housing or a guarantee to dwellings of a particular quality. While some legal advocates argue that this court decision, Lindsay versus Normette, forecloses a right to housing only of a particular quality, others interpret it as entirely closing the possibility of judicial recognition of a constitutional right to housing. And then there are the harbored myths and misconceptions on the nature and practicality and costs involved in effecting such a right. Nevertheless, I argue that the time is ripe for us, as communities of neighbors and of nations, to move beyond the declarations to responsive discourse and policy decisions, and to move beyond investigation to interventions that concretely advance a legal right to housing. Already there are impressive gains in housing rights in the US. That US legal advocacy has won since it began using human rights arguments to advance legal housing rights and remedies for under and unhoused persons and families in the US. These developments and the impulses and innovations that belie them give me cause and should give us cause for optimism that in realizing a legally enforceable right to housing, we will at last bring housing home, making a legal human right to housing less elusive and more fully attainable for all. Thank you.
Thank you very much, Terri Montague.